Good morning, everybody. It's now 10 o'clock, which means it's time for this inquiry to open. Can I just check whether everybody can hear me? Good. If at any time anybody does have difficulty in hearing any part of the proceedings, please do let us know. Because there may be the possibility of contributions from the floor in addition to the tables this morning, we do have somebody with a roving mic to enable everybody to hear what is being said. This is an inquiry into an application by Cambridgeshire County Council for the proposed Cambourne to Cambridge order concerning a proposed guided busway, an associated request for a direction that planning permission be deemed to be granted, and an application for a certificate in relation to the exchange of open space land. A panel of inspectors has been appointed to hold this inquiry and to report to the Secretary of State for Transport on the applications for the Cambourne to Cambridge order and the direction for deemed planning permission, and to the Secretary of State for Housing, Communities and Local Government on the application for a Section 19 certificate. My name is Richard Clegg. I am a Chartered Town Planner and the lead inspector, and I'll be focusing on the need for the busway, alternative options, the effect on East-West Rail, the environment and the green belt.
Good morning, my name is Jeff Underwood. I'm a Chartered Town Planner as well, and I will be focusing on the other elements of the items that were set out in the pre-inquiry note that we issued.
Thank you. I'd also like to introduce the programme officers who are here to assist the panel. Today we've got Mrs. Joanna Vincent, who's sitting on my left. Later in the week we'll be joined by Ms. Brenda Taplin, who will be conducting the same role. The programme officers are working simply to ourselves. Before I go on any further, could I ask anybody who's brought a mobile phone with them or any other electronic device to please make sure that they do have it in silent mode so that we're not interrupted while the inquiry is in session. And just a few other brief housekeeping points. Should the need arise, emergency evacuation arrangements is questioned simply just following the signs at the back of the room where you came in and to your left through those double doors and exit the building following those signs. There's no fire alarm test today, so if it does go off, it is the real thing, and just evacuate as quickly as possible. Toilet facilities are out by the door by which you entered and follow the circulation space round to the right. The inquiry is being live streamed, so people who aren't able to get to the venue can follow it in that way. A pre-inquiry meeting took place about 3 months ago on the 24th of June to discuss the management of the case, and a note of that is on the inquiry website. Core document references 2510. If anybody has any difficulty finding their way to or around the website, please see Mrs. Vincent about that. In the interests of impartiality and openness, all remarks to ourselves need to be made during the inquiry where everyone can hear the comments. There's not an opportunity to make private comments to either of us outside the inquiry, including when we're on the site visits. Accordingly, if we do see you outside this room, including elsewhere in the hotel, we won't enter into any discussion at all on the merits of this case. However, you may of course raise any queries that you do have with the programme officers. What we'd like to do now is take a note of the names of those who wish to speak at the inquiry, and I'd like to start with the applicant, please.
Good morning, sir.
Good morning.
My name is Neil Cameron. I'm King's Counsel, and I have appearing with me Mr. Matthew Henderson of Council, who sits to my right. So you have a list of appearances. It's core document 2508, which we put in at the pre-inquiry meeting.
You did indeed, Mr. Cameron. I was going to check it. Is that exactly the same? Sometimes you get changes between PIMs and the event itself.
No, nobody's dropped out or been...
And no new additions?
No, sir.
Good.
So
That's very helpful.
Would you like me to read out the names of the
Well, I
witnesses?
think not everybody, there's quite a number of people in the room. Not everybody may have been at the PIM. So, yes, please do.
Yeah. So the witnesses who we intend to call, and not necessarily in this order, are Mr. Peter Freeman, who's chair of the Cambridge Growth Company, Mr. Joe Baker, who's a project manager at the Greater Cambridge Partnership, who deals with, he's a transport planner and he deals with transport matters and also the history and development of the proposal. Mr. John Lonergan, who's an engineer who deals with scheme design, construction and operation. Mr. Chris Whitehouse, who is an expert in preparation of business cases, and he gives evidence on the business case and on benefits and need. Mr. Andy Saunders, who gives evidence on environmental matters. Mr. Chris Carolan, who gives evidence on landscape and visual matters. Ian Ellis on ecology. Chris Alder on arboriculture. Toby Lewis on noise and vibration. Tom Wilson on heritage. Jack Southern on flood risk. Paula Reason on bats. James Franklin on property. And Ralph Lewis on planning. So I hope I haven't missed anybody out, but they're the ones on the list.
Yes, I think that did coincide with my list, Mr. Cameron. Thank you very much. Right, so I'm going to follow the provisional list that we've drawn up of who we're expecting to see after the applicant.
And we should have said, sir, we are instructed by Womblebond Dickinson.
Yes.
But I think you know that.
We're aware of that. Thank you, Mr. Cameron, for making that clear. Next, I'd like to come to the district councils.
Good morning, sir.
Good morning.
My name is Esther Drabkin-Writer of Council. I should say we have prepared a list of appearances, which I will hand up in a moment.
Thank you very much.
I'm instructed by Richard Pitt, Principal Lawyer at 3C Shared Services, on behalf of Cambridge City Council and South Cambridgeshire District Council.
Yes.
The Council's proposed to call one witness, Mr. Stephen Kelly, to deal with the aims, objectives of and need for the scheme.
Yes.
Mr. Kelly sits to my right.
Yes.
The Councils may also call Ms. Chengi Taruvinga to deal with planning conditions in due course, and she sits one further to my right.
Okay.
Thank you. Thank you.
Thanks, Mr. Cameron. Thank you, Mr. Drabkin-Writer. Next, Cambridge Past, Present and Future and Cobham Parish Council.
Good morning, sir. My name is Jack Parker of Council. I'm instructed by Lisa Foster of Richard Buxton Solicitors. I have a list of appearances attached to my opening submission, so if I hand that up when I hand my opening up, that would probably be easier.
It would, yeah, but if you could just run through it now, please, Mr. Parker.
I will do, sir. So I will be calling 5 witnesses. Mr. Steve Johnston, in relation to transport modelling and the CPPF alternative scheme. Mr. Edward Lee, in relation to the economic analysis and the CPPF alternative. Mr. Dominic Woodfield, in relation to matters of ecology. Louise Hurst, in relation to CO2 emissions. And Mr. James Littlewood, the Chief Executive of CPPF, in relation to planning matters.
Thank you, Mr. Parker. Is anybody here representing Clare Hall? Ralph, would you like? Yes, you,
Would you like me to speak into the mic?
Have we got a roving mic?
yes. There's no need to move around at this stage. I think one's coming to you.
We need to have the mic for the live stream.
Proper.
No, roving mic.
Yes, coming. Yeah.
Good morning, sirs.
Good morning.
My name is Thomas Horner. I'm from Denizens UK and Middle East LLP, representing Clare Hall. And today we will have Mr. Arrowood Philpott and Stephanie Bruce Smith of Francis Taylor Building representing at the ES Roundtable, but are not here for this part of the session. And I can repeat the list of appearances that we have submitted. I note that on the inquiry website, I don't believe our updated version has been posted on there. So if you'd like me to run through, so there's a slight amendment to the original document that was CD 2509.
Please, Mr. Horner, that would be helpful to both of us.
Of course. So in sort of changing the original list, the removal of David Comboy, who would have been speaking from Newsteer on compulsory acquisition. So the full list will remain Professor Alan Short, speaking on behalf of Clare Hall, University of Cambridge, on Clare Hall itself, Cameron Hayder from Pulsar Transport on transport and alternative routes, Graham Sinclair from Create Consulting Engineers on flooding, Jodie Blacklock from Create Consulting Engineers on acoustics, Fiona Lamb of Avanti Architects on heritage, and Jessica Wilson from Newsteer on planning matters.
Thank you, Mr. Horner.
Thank you.
Right, I'm going to move on to other parties now. Is Mr. Strauss here? No. Right, we had an indication that he wished to speak as an individual in support of the scheme. Next on my list is the owners of Bourne Airfield at the west of the site, which I've got down at the moment as Juniper Propco Bourne Limited. Mr. Baker indicated. Okay. Is there anybody representing the Mayor of Cambridge from Peterborough? North Newham Residents Association. Yes.
I don't wish to speak today, but
No,
we'll have
but-
something coming later.
Right. Do you have a name for us, please? Who it will be?
Can you just
Oh, sorry, we need
can you just wait for the mic? It's just people watching on screen I don't think can hear unless you've got the mic, so just bear with us.
Thank you. Good morning. I'm Chair of the North Newham Residents Association. Our speaker will be Mr. Dai, D-A-I, Davis. And I think he has a date for a couple of weeks' time.
Thank you. Sorry, I didn't catch your own name.
My name is Heather Buchanan.
Thank you. Next on my list is Dr. Green. Right, Dr. Green's not present. Then I've got Friends of the Cam. The mic's on its way to you.
Thank you. I'm Susan Buckingham, representing Friends of the Cam, and I think Ms Vincent is scheduling us for a couple of weeks, and myself and Tony Booth will be speaking.
Right, that's who we expected. Thank you very much. Is there anybody here from Cotton Busway Action Group?
Good
Yeah.
morning.
Good morning.
My name is Dr. Marilyn Tracy. I'm the coordinator of the Coton Busway Action Group. We don't have a definite date yet, and either I will be speaking or Jeremy Spriggs.
So was that Jeremy Spriggs?
Yeah.
Thanks. So it's one speaker, one of the two of you. Thank you. Carolyn Postgate. Yes.
Hello. My name is Carolyn Postgate. I'm speaking on my own behalf and on behalf of Coton Village. I don't have a date for when I'm expected to come.
But we just wanted to check that you did still intend to speak.
Yes.
Can I just check
Yes.
one thing, Ms Postgate? You said speaking on behalf of yourself and Coton Village. Is that a residents group or?
No, it's not a residents group. It's just that I am a
Coton resident?
villager, a Coton resident,
Yeah.
yes.
Thank you. And then I've got Ms Fife. No, not present. Coton Orchard, Houston Crest and Ms Gaisley.
Good morning.
Morning.
My name is Anna Gaisley, and yes, I'll be speaking on behalf of Coton Orchard Limited and Houston Crest Properties, which are just family companies. So it's actually my family that owns the orchard.
Right. So, is it just the two companies you will be speaking on behalf? I think
And myself.
And yourself, yes, that's what.
Because I've lived in the village for 30 years.
Right. And is it just yourself, Ms Gaisley?
At the moment, yes.
Thank you. And then I've got J and W.R. Sandler. Mr. Sandler indicated he wished to speak, but not present this morning. Okay, thank you. That's those are the people we had on our list who'd notified an interest to the programme officers. Is there anybody else in the room this morning who knows now they'd like to speak at the inquiry? The gentleman on the front row there. Mike's coming to you.
Thank you. Good morning. James Peck, owner of Scotland Farm.
See, was that James?
James Peck, yes.
Peck. P-E-C-K?
Correct.
Scotland Farm. Right. And do you wish to speak in support of the proposed order or against it, or simply to make some other form of representation?
I'd like to. I'm in favour, but I'm negative about the conduct and way I've been treated and the mounting bills that haven't been settled.
Right. So you have some concerns about how things have been dealt
I do,
with.
yes.
Okay. Thanks, Mr. Peck.
Thank you.
When there's an opportunity, would you have a word with Mrs. Vincent and to make arrangements for an opportunity for you to address the inquiry? I said, we've made a note of Mr. Peck. Is there anybody else? Nobody's indicating at the moment. What we will do is check again later on towards the end of the inquiry whether there is anybody else who does wish to say something to us. Is anybody here representing the press? Two people on the far side. Thank you. And can I just ask, is anybody intending to either film or record in any way the proceedings? I thought I saw you, Ms. Gaisley, earlier on with a camera taking photographs. I think before there's any more of that, I do need to check whether anybody has any objection. Bearing in mind that the event is being live streamed, hopefully it won't be an issue. But
could you just bring the microphone to Ms. Gaisley? Could you just set out what you're doing in terms of recording, just so we understand what you're doing?
I get a lot of press interest, and one of the requests is that I supply photos.
So are they still photos or video photos?
Both, probably. But as you said, the video they're likely to take off the live stream. To be honest, I hadn't really thought it through. I'm a photographer by trade as well, so I just take pictures.
I don't think there's any objection to photographs, but if there's anybody in the room who doesn't want their photographs taken, we do need to check that before any further ones are taken. Can I just ask, is there anyone who, if somebody in the audience is taking photographs in the inquiry?
No.
I can't see anyone objecting to that. So
Okay,
Thank you.
Thank you.
And then I think there was the two people from the press next, wasn't it? Thank you.
On the far, yeah. Right, thanks. In due course, a copy of our report and the government's decision will be available on the government website.
Just need to check who's from the press.
We know. Which organisations? Yeah, you can check. You can check that, Jeff.
So, can we just check that? Sorry, there's two people who indicated they're from the press. Could you just sort of let me know which organisations you're from and representing?
Yeah, absolutely. It's Phil Shepka from the BBC.
Sorry, I missed your name there.
Phil Shepka, Shepka.
And Mr. Shepka, how are you recording today's event? Are you making notes or taking photographs? Or?
I'm making notes. Yes, I have my notepad in front of me.
Thank you.
And there was the lady in the white top.
My name's Hannah Brown. I'm based at Cambridge News, Cambridgeshire Live. I'm also the local democracy reporter for the area, which is a BBC-funded scheme that means my stories are shared on a newswire with others.
And are you just taking notes? Is it?
Yes, just taking notes.
Thank you for confirming that. Thank you. Sorry, Richard.
That's okay. Next, I just want to check with the applicant whether all necessary statutory requirements have been complied with. And we do have a procedural note was previously prepared, I think dated the 19th of June. It's core document 2504, and that was put in at the pre-inquiry meeting, but we just wanted to, now that we're into the formal inquiry, just check the position again.
Yes, sir. My microphone's turned on. It is. That note dealt with the order-making process and the application-making process, and that's all correct, and the requirements have been complied with. So can I then deal with the notification of the inquiry, which is the next step which needs to be taken after that?
Yes.
And so it may be, because of what I'm just about to direct your attention to, that it would be helpful to have the 2004 rules in front of you. And those are core document 517. And so could you, when you've got that, go to Rule 13, please. And Rule 13 sets out how notice is to be given of the inquiry, and I'd like to draw particular attention to Rule 13.6, and that says, for those who haven't got it, unless the Secretary of State otherwise directs and subject to paragraph 7, the applicant shall not later than 2 weeks before the date fixed for the commencement of an inquiry do three things: post a notice of the inquiry in a conspicuous place, or in the case, which this is, of an application for an order making provision for land-based linear works more than 5 kilometres in length at intervals of not more than 5 kilometres on or as close as reasonably practicable to the land to which the powers sought in the application relate. B, post a notice of the inquiry in one or more places where public notices are usually posted in the area in which the proposals contained in the application relate. And C, publish a notice of the inquiry by local advertisement in the area in which the proposals contained in the application are to have effect. Now, sir, the provisions at paragraph 6A notice of the inquiry in a conspicuous place along the route being complied with, and if necessary, we've got photographs. The local advertisement in the newspaper has been placed. But in relation to B, posting a notice of the inquiry on one or more places where public notices are usually posted in the area, there was an oversight on that issue, and although a notice has been posted today, it wasn't posted 2 weeks before. Now, sir, these provisions are in place unless the Secretary of State otherwise directs. And I should draw to your attention, sir, before you make a decision on this matter, that a request has been made for the Secretary of State to consider a direction that that provision need not be complied with, and the Secretary of State is considering that. So if the Secretary of State were to so direct, no issue would arise, and that would be the end of the matter. However, sir, it is a requirement in the rules, and you'll need to decide what to do about it if the Secretary of State doesn't so direct. And so what I'd like to do is just to set out the approach which we submit you should take to this point. The principles are set out in a number of cases when a procedural rule is not complied with. And the courts in recent years, for the last, well, for some time, have expressed it in this way, and I'm quoting here from a case called A1 Properties, which we don't have in the core documents, but for those who wish to follow, it's 2024 3 Weekly Law Report 601, and I'm going to read from paragraph 61. And there's reference to a revised analytical framework. The point of adoption of the revised analytical framework in Sonegi was to move away from a rigid category-based approach to evaluating the consequences of a failure to comply with a statutory procedural requirement, and to focus instead on the purpose served by the requirement as assessed in light of detailed analysis of the particular statute, that's A, and B, the specific facts of the case having regard to whether any and what prejudice might be caused, or whether an injustice might arise if the validity of the statutory process is affirmed notwithstanding the breach of the procedural requirement. So the principle is one considers the purpose served by the requirement, and then the specific facts of the case and whether any and what prejudice might be caused. So as far as the purpose is concerned, it's to give notice of the inquiry, and in particular to those who are not active participants. Because if you're an active participant, you will be covered by other rules, such as submitting proofs 4 weeks before the inquiry starts. And so by the time it's 2 weeks before the inquiry, you know about the inquiry because you've got to put in your proofs 4 weeks before. So it's directed at those who are not active participants. They see the notice and they can come to the inquiry and be allowed to speak at your discretion. Now, as this inquiry is going to last for more than 2 weeks, if notice is given today, which it has been by posting on the South Cambridge District Council notice board and on the Cambridge City Council notice board today, this morning, they can come along in 2 weeks' time and seek your permission to appear and say something. And the notice gives, it's the same notice that was posted on the land. It gives the programme officer's details, telephone numbers, email. It explains what the application is for, and it enables people to obtain the information. So it's our submission that no actual prejudice would be suffered in this particular case. If it was a one-day inquiry, it could well be that prejudice would be suffered, but this isn't. It's also right to consider the context. And you, sirs, will be familiar with planning inquiries and the Town and Country Planning Inquiries Procedure, England Rules 2000. That has a provision at Rule 10.6, which provides for notification, and that's as directed. And in that case, it can be neighbour notification, local advertisement, as directed, one or the other or both. But there's no equivalent provision to Rule 13.6b, which is the notice in the usual place provision, which hasn't been complied with in time here. So it is an important part of context that for a planning inquiry that wouldn't be necessary in any event, and that gives you a context of how important this provision is in the particular circumstances. And we say it gives an indication it's not as important as the other provisions. And of course in this case, notice of the inquiry has also been published on the website, which is not a requirement, but it has now become the normal way of publicising such things. So it's our submission to you that you should proceed today, wait to see what the Secretary of State does, because if the Secretary of State gives a direction, then there's no failure to comply. If the Secretary of State doesn't give that direction, then you should, of course, consider the matter, but it's our submission to you that there is no actual prejudice, because if an interested party sees the notice and contacts the programme officer, they can then be allowed to participate and to speak because the inquiry is going on for more than 2 weeks. So, sir, I draw all those matters to your attention because this has been recently discovered, and it's right that we should tell you about it.
Thank you, Mr. Cameron. I think a couple of things. First of all, documents. The request that's been made to the Secretary of State, could you provide a copy of that, please, if that's not already been done to the programme officers?
Yes, sir, we can. I'm told it was a telephone call, and then there's a response by email from the Secretary of State.
There's an email exchange.
But in that email, and you just give me one moment, I'll get it in front of me. It is said, it's an email from my instructing solicitor reporting on the call to me, and he says she, that has been the officer at Tipu,
yes,
has said to raise it with the inspectors and she will come back by lunch. So I'm raising it with you because that's what I've been told. So there isn't an actual, it was a telephone call. So there isn't an email.
So you haven't, so have you or haven't you formally requested that from the Secretary of State then? It sounds like the Secretary of State's office are waiting for inspectors to say something, is that correct?
No, I don't think, as I understand it, so I wasn't on the telephone call. It has been raised with the Secretary of State, and the official asked that the inspector raise it with the inspectors, i.e. to tell you that it had been raised with them. I mean, they may decide to do nothing, they may make a decision, but if they do make a decision to make that direction, then there will be nothing for you to consider. But if they don't make the direction, there will be something for you to consider.
So they're clearly aware of the situation, but there's nothing in the...
They haven't decided anything.
No, but there's nothing in the form of the formal request from yourselves.
No, other than the telephone call.
When was that made?
This morning.
And that was with Tipu.
That was with an official at Tipu, yes,
Right.
at the Department for Transport.
You quoted from a particular part of a judgment. I think you said it was A1 Properties.
Yes, I can submit that.
I think we need that for context.
Certainly, and also if you, like, it refers to the principles in
Yes.
Sonergy. I mean, I can submit that as well if you'd like. I think A1
I don't really want to
Properties
collect a
is
lot
probably
of judgments,
Yes.
Mr. Cameron. The key one that you referred to in your
We'll submit
submission.
A1 Properties.
Thank you. And just one point about the telephone call that took place this morning. Did Tipu give any indication of when they might respond? Or,
Can I just check? Well, I'm told that they said they would respond by lunchtime today, which would be
yeah, helpful.
very helpful.
Right, okay.
Mr. Cameron, you mentioned where the notice has been posted, South Cambridgeshire and Cambridge City Council notice boards. Where are they?
Well, South Cambridgeshire offices are very close to here. They're in Cambourne. And the City Council offices are, I'll check, the Guildhall in Cambridge.
Oh, so they are physical notice boards, not
They are
virtual.
physical notice boards.
Yeah.
I mean, if it was a non-physical notice board, it's gone on the website
Yes.
already, so that's been done.
Yes.
As we understand the rules, it's a physical notice
Yes.
board.
Yeah, thanks. Do you have anything else?
I just wanted to double check that, and as you're aware, are those the areas where public notices are usually posted?
My instructions are that is the case. It's on a notice board that is used for that purpose. I mean, it's less often that those type of notice boards are used these days, but the rules refer to this provision.
Yeah. Okay. Just before we move on, now that Mr. Cameron's raised this matter, this oversight that's occurred, are there any comments from any other parties about it?
Nothing I want to
Parker.
say now, but I'll take instructions just in case.
Yes. Okay. Right. Well, we'll wait here then, Mr. Cameron. If there's anything that arises later in the day.
Thank you, sir.
Thank you. Just a brief word about responses to the application for the order. There have been in the order of about 300 objections. In addition, 13 representations of support and 12 other representations, and they should all be found, for those who want to check, in section 2 of the core document library on the website. In addition, there were a further 3 objections made to the section 19 application. I think you'll find if you refer to it, the website, there are 4 listed there, but I think we need to check the position of the County Council, because the County Council is, of course, the promoter of the proposal, but I think a particular branch has put in a comment on the section 19. And finally, on responses, 2 objections have been withdrawn. There will be a separate section of the Core Documents Library dealing with withdrawals, and the ones that have been withdrawn are from the National Trust and the Environment Agency. Next, a word about procedure and timetabling. This inquiry is being held in accordance with the Transport and Works rules to which Mr. Cameron's just referred, and also with regard to the discussion that took place at the pre-inquiry meeting back in June. The intention has been that following roundtables which will take place later today on proposed modifications to the order and on the environmental statement, the applicant will present its case on the overall scheme, followed by other parties who wish to comment on the scheme as a whole, then to deal with site and objector specific matters. And that was set out in the note on the pre-inquiry meeting, particularly at paragraphs 20 and 22. We do appreciate that that overall approach may have to be adjusted because of the availability of parties. After each person has presented his or her evidence, there would normally be an opportunity for questions to be put by those parties who hold a contrary view. To ensure the smooth running of the inquiry, the intention has been that the intention to ask questions should be made ideally through the programme officers so that arrangements can be made for availability. At the time of the pre-inquiry meeting, it was expected that 8 weeks would be required for this inquiry. It does seem to us that that should be sufficient. Can I just check the views of the main parties around the table about that? Mr. Cameron.
Overall, yes, sir. But of course, it depends on programming and availability. And I appreciate the programme officer has a very difficult task here because of the number of parties and availability. It may be that we take up those 8 weeks with evidence and perhaps have closing at a later date, even online, but subject to that proviso, with a fair wind, yes.
Thank you, Mr. Cameron. Any other thoughts on the overall length of the event? Nothing from Mr. Parker, I can see.
No,
No.
thank you.
Nobody else is indicating. Okay, thank you. In terms of the arrangement of inquiry days, they often start at 10 o'clock as this morning, but we may consider early starts, and I think the timetable in its present form has suggested 9:30 for most subsequent days. We generally be looking to finish at a convenient point in the proceedings, round about 5 o'clock, with the exception of Friday afternoons, when due to travelling commitments for Mr. Underwood and myself, we will need to finish early, probably just before 4 o'clock. We will be taking mid-session breaks in both the morning and afternoon parts of the inquiry. And in terms of where the inquiry will be taking place, after today, the inquiry sessions will be in the Magdalen room in the hotel, which is on the other side, on the corridor that goes down the hotel on the other side of the reception desk, with the exception, as I understand it, on the last day of the inquiry, when the venue will be moved to the council chamber at South Cambridgeshire Hall. Unfortunately, it was not possible to finalise the timetable for this inquiry as early as we would have liked. As Mr. Cameron's already alluded to, it's been a complex exercise given both the number of parties who want to participate and the number of witnesses that some of those parties are calling. And to try and fit that in with the broad structure that was set out in the pre-inquiry meeting note. As things stand, the programme for this week has, I think, been more or less finalised and is pretty well firmed up for week 2. There are still ongoing discussions with the programme officers on subsequent weeks. Hopefully those will be finalised as soon as possible, but there is a timetable in various stages of formality now on the inquiry website, but it is in any event likely to change in detail because of the issue of availability, so please do keep checking the latest position on the website. If anybody has any queries or concerns about that, they should contact Mrs. Vincent, or when she's here, Ms. Taplin. Are there any particular points on the timetable that any party wishes to raise in open session before I move on?
So,
Mr. Parker.
Just to confirm exactly what you've said, are you happy for us to raise concerns about, well, for example, the witnesses that CPPF are calling, the order of those witnesses, when they might be heard? Are those concerns best raised with Mrs. Vincent in the first instance in discussion with Mr. Cameron rather than in the inquiry open session?
I suspect so. I mean, you can obviously have discussions outside the inquiry, Mr. Parker. I think this was something that was raised at the pre-inquiry meeting, and which we addressed in the pre-inquiry meeting notes. And I think there's been some movement from that simply because of, I think, essentially availability, whilst trying to respect the overall intention of what the pre-inquiry meeting note said. But yes, please discuss those outside the inquiry. Liaise with Mrs. Vincent, and she'll keep us up to date. Anybody else? Okay, thank you. Just a word next about conditions. We propose, after we've heard the parties present their different cases, to seek views on possible conditions relating to the application for deemed planning permission. We do just want to emphasise that having that discussion at the inquiry does not at all indicate any prejudging of the case, and it's not intended to weaken any party's position. It's simply standard practice to consider conditions in the event that the Secretary of State does agree to the request that planning permission be deemed to be granted. There is a list of possible conditions which is included at Schedule 1 in Core Document 114 for reference. I also need to say a brief word about costs applications. Awards of costs may be made on the ground of unreasonable behaviour. One application has been received from Clare Hall. Mr. Cameron, what's the position in terms of a response? You'll know that in the pre-inquiry meeting note we were hoping for responses in writing before the inquiry opened, and I think that was acknowledged in a communication to the programme officer. And I think the point that was made was, because of everything that was going on, there would be some delay, but we would get it before today. I haven't seen it yet.
You haven't got it, sir, and we're taking instructions on that because there are some quite detailed factual points.
Yes.
And we do intend to respond in writing, sir.
Yes, thank you. Can you give me an indication? I don't think Mr. Unwood and I are unduly concerned at the moment, and cost applications would of course be dealt with at the end of the inquiry.
Well, that's what we had in mind, sir, but we will get it in as soon as we can. But I'm not promising it within the next week. It will be
by the end of block 1,
or perhaps by the beginning of block 2.
Yeah, I think we can accommodate that.
Thank you, sir.
Right, so as things stand, the position is a cost application is with us from Clare Hall. Does any other party at the moment know that they intend to make an application for costs? If parties do, it's much better to have that known now rather than suddenly arise right at the end of the inquiry. I'll make a note that nobody's indicated that. We will, of course, check at the end of the inquiry what the position is. Site visits are the next item to refer to. As I think we mentioned at the pre-inquiry meeting, we had seen a few parts of the route the day before the pre-inquiry meeting. The intention is, the timetable makes clear, that we do intend to make some visits tomorrow to provide inquiry for the inquiry sessions which are to follow, and there will be a thorough, comprehensive programme of site visits towards the end. I think the only other thing I need to say about site visits for tomorrow is that the weather forecast is not looking good as things stand. I'm told it's likely to be the worst day of the week for weather. Whilst I hope that's not true, Mrs. Vincent will be looking to discuss with parties who are scheduled for tomorrow afternoon, whether there's the possibility of a plan B and a swap round, because it appears that things might improve in the afternoon.
Well, so we don't want to be the cause of you getting very wet, but that's not possible for us because our witness, Mr. Freeman,
Yes.
is our first witness, and
I
I'm
know.
afraid he's not available in the morning, just the afternoon.
Yeah. Okay. Well, hopefully, we just wanted to have a contingency available, and we may have to explore something else, because it is important that we have that understanding at an early stage in the inquiry. So we'll leave that with Mrs. Vincent for discussions outside the inquiry. I just want to move on with a number of points about documentation. I've already mentioned the inquiry website, which is where all the core documents, proofs of evidence, the application, and all the other documents that have been submitted should be able to be found. One set of documents that we hoped we might receive, but we haven't, is statements of common ground. This was raised at the pre-inquiry meeting, and I think the position was, Mr. Cameron, that the applicant identified a number of parties who it might be possible to prepare statements of common ground with, and was seeking to pursue that with them. Could you just give me an update on the position since then?
Well, it has been pursued with them, sir, and the applicant's team have prepared drafts
Yes.
of a number of statements of common ground, but none of them have been completed. So we have been trying, but have not yet succeeded.
Okay. Good, Jeff.
Does this include statements of common ground with those land interests where you're confident or you've got agreement? Or were those not part of it?
They're not, I don't think they're part of that, sir.
Yeah. I mean, correct me if I'm wrong, but did we ever get a list of which parties you were seeking to?
Yeah.
Did we get that? Okay.
Yes, sir.
Yeah. Right. It is disappointing when statements of common ground aren't finalised, because they can be quite helpful, particularly in assisting us to focus on the real areas of dispute between the parties. So I think we just have to register our concern that things haven't been progressed with other parties, despite the efforts of the applicants.
So can I just briefly comment?
Mr. Parker,
because
yes.
the position is slightly more complicated, I think, than Mr. Cameron would suggest.
Okay.
It's right that the applicant circulated prior to the proofs of evidence a draft statement of common ground, and it's right that that wasn't progressed by CPPF and CPC for reasons that were explained in an email to the applicant. So we would hold our hands up that I think we would take responsibility for the failure prior to the proofs of evidence. When the proofs of evidence were submitted, it's clear that the statement of common ground that had been drafted wouldn't have covered, frankly, the issues that were in dispute and remained in dispute. CPPF and CPC have now circulated a draft statement of common ground which reflects the updated position in light of the proofs of evidence to the applicant, holding its hands up that it didn't progress it beforehand, but recognising that it might still be useful to you to have a statement of common ground which identified in neutral terms the issues that remained in dispute following the proofs of evidence. That was circulated, I'm not exactly sure of the date, I think at some point last week, and we haven't, as far as I'm aware, instructed, haven't had a response to that. So I think we would certainly bear some of the responsibility for failing to progress that prior to the exchange of proofs, but we have sought to remedy that, and we are still willing to try and enter into a statement of common ground which at least records the issues in dispute to achieve the purpose you've identified for it. So I just wanted to flag that up.
Thanks, Mr. Parker. Did you want to come back on it, Mr. Cameron, or?
I don't think so. If there is common ground, we're very happy for it to be recorded.
Yes.
I mean, we've just asked, having heard that, whether anybody had seen the CPPF draft. I haven't, but we will, so there's no point debating it here. We will, if there's a statement of common ground on offer, we'll definitely consider it.
I think it's something we mentioned at the pre-inquiry meeting as well. The statements of common ground are very helpful, not just in terms of that ground which is common, but I think, as Mr. Parker mentioned, it's just now that we've got all the proofs and rebuttals, just a clear agreement, if possible, about those areas which are still in dispute would be really helpful. So I think it is just asking sort of all parties if they can. Engage in that process, even if you think there's not many things you agree on. I think recording those items that are in dispute and just being clear about that would be very helpful. Thank you.
Well, our door is open to that, and it would be certainly as advocates, like with you as inspectors, it's very helpful because you know what to concentrate on.
Yes, exactly. So you can pursue that, Mr. Cameron, with your team, with Mr. Parker's team. That would be helpful. Mr. Horner, I think the mic's on its way to you.
Thank you, sirs. I'd just like to similarly reiterate that Clare Hall are willing to enter into a statement of common ground that is being progressed. Admittedly, given the volume of documentation and rebuttals that the college has been looking to prepare, possibly hasn't progressed as much as we'd have liked. However, it was returned to the applicant, I believe, yesterday, namely updating the record of engagement. However, there is further work to be done on other points, but we also intend to enter into one and will continue to do so.
Thanks, Mr. Horner. Well, could we request that in both cases that we've heard about where other parties are willing to enter into a statement of common ground, that you endeavour to get that resolved by the end of this week?
We'll certainly endeavour, sirs, but to the extent that that's possible, I'm not quite sure, but there are quite a lot of points.
I don't want it to drag on much more into the inquiry itself, because it starts to lose its advantage.
No, that's understood. And I think there is an acceptance between ourselves and the applicant's team that we would like to see progression over the next couple of weeks, so I hope that that is possible.
Okay. Mr. Cameron, did you?
No. We would like to see it progressed as well, so it's down to us and down to the objectors to progress it, and we take the message there.
Good, thank you. We've received a large number of proofs of evidence and statements from parties, and in a number of cases rebuttals which were provided for at the pre-inquiry meeting. There have been a couple of attempts to submit what I would term counter rebuttals in response to rebuttal that's come in, and we're resisting those. The intention was quite clear. Objections have been made, statements of case have been submitted, parties have elaborated on that in their proofs of evidence and statements which were made subsequently. And clearly they may raise points that people want to respond to, and rebuttals are the place for that. It can't continue to go on. In similar vein, there have been a number of other documents which have been submitted to the programme officers and accepted, because they are documents which I think in all cases are referred to in the evidence that's already before us. But we don't want a continuing drip feed of documentation during the inquiry itself. If there are other documents which parties consider that are relevant to this case, we do want to be alerted to those in open inquiry sessions, and we would be looking for a good reason why they're being submitted now at this stage after the lengthy lead up to the inquiry. We're not intending to accept further representations on the same themes that are already before us in evidence, and I just hope that is clear. I think there's just a couple of other points on documentation. The first concerns the description of development in relation to the request for the direction concerning the deemed planning permission. We asked for that to be set out at the pre-inquiry meeting, and we have received a document of that, but it's been submitted by the applicant, and it's an extremely detailed description of development. It's a full one page. We are really looking for something more concise, Mr. Cameron, than that. Something. There is. I'm not saying you should use this, but on the inquiry website from Gately Hamer, there is a summary of the main elements of the proposed works, which it might be worth using as a guide. But I don't think we need full details saying how many metres in length the various sections of realignment are. That's not what we're looking for. We're looking for the form of words that you'd normally put on a planning application form.
So the difficulty, if I can put it that way, that
yes.
we've tried to comply with your request, we've produced the document.
Yes.
But as I sought to say at the pre-inquiry meeting, and I'm going to say it again now, one needs to, just turning to the provisions of section 90 of the Town and Country Planning Act 1990, which we've got in as core document 508. And what section 90 subsection 2A provides is on making an order under section 1 or 3 of the Transport and Works Act 1992, which includes provision for development, the Secretary of State may direct the planning permission for that development shall be deemed to be granted. And therefore the request that we've made is for an order in those terms,
yes.
which is for the planning permission be deemed to be granted for the development which is provided for in the order.
Yes.
And what I'm concerned about, we're very happy and we tried to provide the description of development you asked for, but that doesn't affect the deemed planning permission that we are seeking. We are seeking a direction in accordance with section 90 subsection 2A.
Yes.
So that's for all the development proposed.
Yes.
We made it shorter, but it could be longer because that's what we're applying for. So all it would be a summary to assist you. It's not equivalent to the description of development or the operative words in a actual planning permission which we're not seeking. We're seeking a direction. That's why we're finding this difficult, sir. Because if you have a planning permission that's granted as opposed to a direction, you do have a description of development, and then you can't have conditions which are inconsistent with that description. You can't change that description later. But it's different for a direction because the direction is governed by the provisions of section 90 subsection 2A. So if it's just to help people, give them a general idea, we understand it.
Yes.
But we don't understand otherwise really what the purpose of this is.
Well, in terms of providing, as you term it, Mr. Cameron, a general idea, certainly at the beginning of our report, we will be looking to provide an overview of the development. And I mean, we can provide that ourselves, but it'd probably be helpful if it came from you in the first instance.
And so you're looking at something less detailed than the document that we put in?
Yes.
I have to say I'm concerned about how that might be used because of the terms of section 90 subsection 2A. But if it's just meant to be a helpful summary,
yes,
then we'll make it shorter. But
Okay. I'll leave it with you.
Thank you, sir.
We have helpfully received hard copies of the site plans for the development works. I think by the end of the inquiry, it would be useful, Mr. Cameron, if the applicant could provide copies of the works and land plans as well for our reference, rather than us just relying on the plans on the screen. Have you anticipated that?
No, but I'm with you, sir, because I asked for them. So I've got them.
You've
so
got them, and we haven't.
we'll make sure you've got what I've got.
Yeah, so...
I mean, you can have this now if you'd like.
Well, no, except for myself and except for Mr. Underwood would be very helpful.
Thank you.
Yeah. Good. I think that at the moment that is it on documentation. We need to refer next to the main considerations as we see them in this inquiry. They're set out in the pre-inquiry meeting note. I think it's at paragraph 13, so you can find that on the website. And they reflect the revised statement of matters which was issued by the government. And yeah, I think we're now on the third iteration of that, but the statement of matters that you need to refer to is dated the 11th of August 2025, because there were some detailed typographical points that needed to be amended. I mean, it is possible that our view on the main considerations may be modified as a result of the evidence that's presented to the inquiry, and other considerations, of course, may emerge when we hear participants. If anybody does disagree with our understanding of those considerations, we'd like them to make their views known as and when they present their cases. And that covers the initial points that we wanted to deal with in opening. We'll be moving on to requesting opening statements shortly. Before we do that, does anybody here have any queries about the procedure and the arrangements for the inquiry? If not, it's our intention then we'll take a short break now, a 10-minute break in proceedings, and then when we resume, Mr. Cameron, we'll invite you to make an opening statement for the case on behalf of the applicant.
Thank you, sir.
Thank you. So the inquiry is now adjourned. It's just approaching 10 past 11, so we'll resume, please, at 20 past 11. Could you all take your seats, please? My computer's telling me it's exactly 11:20, so we need to resume. Thank you. And it's time now to hear the opening statement on behalf of the applicant. Mr. Cameron, please.
Thank you, sir. You should have a written copy of the opening.
Yes.
And we've circulated some written copies and we've sent it to the programme officer, so
Thank you.
Hopefully everybody will have access to it. So, going to turn to the opening. In introduction, a striking feature of this case is the near universal agreement that there is a need to provide a reliable public transport service between Cambourne and Cambridge. The proposed guided busway, which we're going to call the busway, will meet that need. The fact that there is agreement on these matters is striking, but it should not be surprising because the need for new transport infrastructure is a key feature of both national and local policy, both in that which is adopted and that which is emerging. So that's particularly in relation to local policy. At a national level, there is very strong cross-party support for the growth of Cambridge, including the delivery of new transport infrastructure to support that growth. In 2024, the last Conservative government published the Case for Cambridge. The Case for Cambridge supported significant housing and employment land growth, in particular new space for laboratories and research, underpinned by fast and reliable public transportation with a wealth of options for walking and cycling. These improvements are needed now. As the Case for Cambridge explained, severe road congestion is already a feature of daily life in Greater Cambridge. This has a human consequence. It leads to journey delays, frustration for local people, poor air quality, and related health consequences. It also has a critical economic consequence. Pressured public transport and poor connectivity is constraining the local economy, wasting time, and is inefficient for everyone. The case for Cambridge could not be clearer. As Cambridge grows, the provision of sustainable and efficient infrastructure will determine whether it becomes a better place in which to live, work, and study. Easy movement at a human scale will be a crucial component in the high-growth, high-productivity Cambridge of the future. The Greater Cambridge City Deal puts the position even more starkly. The success to date, known as the Cambridge phenomenon, has been widely celebrated, but is now contributing to a shortage of housing and significant transport congestion that threatens to choke off further economic growth. The policy of the current Labour government continues the main tenets of the Case for Cambridge. At the end of last year, the Housing Minister, Matthew Pennycook, reiterated that, and this is a quotation, Cambridge faces significant barriers to growth and there are increasing pressures for local residents and communities, such as expensive housing and traffic congestions. It follows that there is very strong support at a national level for improvements to the transport infrastructure in Greater Cambridge. The busway is precisely the sort of new infrastructure that is needed, and it benefits from this very strong national support. There is also very strong support at a local and regional level for improvements to the transport infrastructure in Greater Cambridge and for the busway in particular. The local plan policies that promote significant growth at Cambourne and at Bourne Airfield are premised on the provision of bus service improvements with a specific reference to a busway on the A1303 corridor. Similarly, the future housing growth in the emerging development plan is predicated on the delivery of the busway. There is a very good reason for this support at local, regional and national level. Cambridge is one of the UK's most important economic assets and global centre of innovation, home to the largest life sciences cluster in Europe. The unique innovation ecosystem that has emerged in Greater Cambridge over the past 50 years has been a phenomenal success. Life science firms in Cambridge already contribute nearly £3 billion annually to the UK economy. In these circumstances, it is untenable and unconscionable to stand by and let clearly identified constraints curb the future growth of Greater Cambridge. Put simply, and again we quote, the size of the economic prize and the potential contribution Cambridge can make to the UK economy is significant, and unleashing the economic potential of Cambridge is a national imperative. The City Deal is the principal funding mechanism to tackle these challenges. The City Deal brings together Cambridge City Council, South Cambridgeshire District Council, Cambridgeshire County Council, the University of Cambridge, and through the Greater Cambridge and Greater Peterborough Enterprise Partnership, local businesses, colleges and research facilities in the area. Within this group, the City Council, the District Council, the County Council and the University of Cambridge have formed the Greater Cambridge Partnership to drive the delivery of the City Deal. The City Deal includes an ambitious programme to enhance transport capacity in the area. This transport capacity is needed along key strategic corridors to and from the city, particularly along those corridors where significant new housing and/or economic growth is planned. And the corridor between Cambourne and Cambridge is precisely such a location, and the busway is a priority scheme for this specific purpose. It is in this context that this inquiry opens. The County Council, on behalf of the Greater Cambridge Partnership, seeks, through the proposed order, and requests that a direction be made that planning permission be deemed to be granted, and through that authorisation to deliver and operate the busway to contribute to Greater Cambridge's continued success. Although there is near universal agreement that Greater Cambridge needs new transport infrastructure to the west of Cambridge, the County Council and the partnership overall appreciates that the precise form and route of the busway is both supported and opposed by members of the community. As this inquiry will hear, those living closest to the new busway or owning land on or near the busway's route have the loudest concerns. The County Council and the GCP have not ignored those concerns. A careful process of assessment has been undertaken, adverse impacts have been identified and mitigated, and residual impacts have been minimised. And ultimately, the busway is policy compliant with the planning balance tilted firmly in favour of the scheme. We now turn to the application, the applicant and the GCP, and this is going to involve a little bit of repetition of the points on the direction that we seek in relation to planning permission. So there are three principal components of the application. First, the application pursuant to Section 6, the Transport and Works Act, for an order under Sections 1 and 5 of the Transport and Works Act in terms of the draft order prepared by the applicant. The proposed order will authorise, it's Transport and Works Act 1992, but there we go. The proposed order will authorise the construction and operation of a two-way 13.6 kilometre long guided busway connecting Cambourne in the west to Cambridge in the east. It will be segregated from local highways except for stretches along St Neots Road, south of the A428 at Hardwick, and on privately maintained Charles Babbage Road on the University of Cambridge's West Campus. An emergency and maintenance access track will run alongside the segregated sections of the busway and will be used as an active travel path. in addition to its primary purpose of maintenance and emergency access. A travel hub will also be situated at Scotland Farm, providing a park and ride facility. And then we turn to the direction. Secondly, a direction that planning permission be deemed to be granted is sought pursuant to the Town and Country Planning Act for the development authorised by the proposed order. And although a description of development, and we give the reference, has been provided at the inspector's request, the County Council reiterates that its request for deemed planning permission is expressed in the conventional way by reference to the development to be authorised by the proposed order rather than a freestanding project or set of works. And that's what I sought to say earlier. The plans for both the proposed order and the request for deemed planning permission are the same. Thirdly, third element, the application for a certificate under Section 19 of the Acquisition of Land Act 1981 is made in respect of two parcels of land, namely plots 14153 and 154, which are small parcels which lie adjacent to the M11. Both plots are considered to be open space, being land which may be used for the purposes of public recreation, and the land offered in exchange is identified in the order as plots 14144C and 144B, and they are to the west of the M11. As far as the applicant is concerned, the County Council is the local highway authority and is the applicant on behalf of the GCP, because although the GCP is the local delivery body for the city deal and is both promoting and leading on the delivery of the busway, GCP, that's the partnership, is not empowered to make an application under the Transport and Works Act 1992. The application documents and the County Council's evidence explains the role of the GCP, its functions and separation of functions with the County Council, but because of the issues that arise, we're just going to give some explanation now, so it's all set out. The GCP is a joint committee of the three councils established by the County Council under the Local Government Act 1972 and the City and District Councils under the Local Government Act 2000. The Executive Board is the decision-making body for the GCP. It comprises voting representatives of the three constituent local authorities with non-voting representation of the business sector and the University of Cambridge. And the Mayor of Cambridgeshire and Peterborough is a non-voting invitee to the GCP Executive Board at the discretion of the Chair. In addition to the County Council's role as part of the joint committee, the County Council also acts as the accountable body for the GCP and accounts for city deal funds. A body which has a power to promote bills in Parliament has power to apply for a TWA order. A local authority, including the County Council, has the power to promote bills in Parliament, and the power to promote bills in Parliament has not been delegated to the GCP, and that's why the County Council is the applicant. Now turn to the relationship between the County Council and the Combined Authority. The Combined Authority was established under powers conferred on the Secretary of State by the Local Democracy, Economic Development and Construction Act of 2009, and then the order establishing the Combined Authority is the 2017 order, which is in our core documents. Functions of upper tier authorities as local transport authorities under Part 2 of the Transport Act 2000 are exercisable by the Combined Authority. Those functions include preparing local transport plans, and additionally the Combined Authority is a franchising authority for bus franchising under Section 123A of the Transport Act 2000. And, sirs, we're setting this out in the light of the Mayor's representations. The Combined Authority operates under a constitution. We then set out paragraph 7.1.6.2 of the Constitution. It's worth reading out. A decision on a question relating to A, the transport plan, B, any spending or plans for the allocation of transport-related funding requires a vote in favour by at least 2/3 of all members or their substitute members appointed by the constituent councils, to include the members appointed by Cambridgeshire County Council and Peterborough City Council or their substitute members. And it follows that a decision to make a transport plan or to spend money on transport-related matters, such as bus franchising, can only be made with the support of the County Council and Peterborough City Council. But that's...
Mr. Cameron, can I just... Sorry to interrupt, but I'm just a bit unclear about the reference to Peterborough City Council.
Well, that's one of the partner bodies.
Was it mentioned earlier?
In the combined authority. Not in the GCP, but in the combined authority. So not mentioned earlier. This is the combined authority constitution.
Right.
So this is how the combined authority operates. This is different from the GCP.
Yes. But I don't think you've set out which are the constituent parts of the combined authority.
We don't set it out here, so we can tell you who they are, but
it includes Peterborough City.
It includes Peterborough City because it's the mayor, and the combined authority is for Cambridgeshire and Peterborough.
Yeah.
And it's just that the two, I don't want to, I was going to say main authorities, but then I was hesitating because I don't want to, and I'm reminded that they are the highway authorities, and because they're the highway authorities, and this is in relation to transport-related powers, they have to be in favour. That's the short point. So I turn to what we're now going to do is set out in outline our case on the matters, so that you have an outline of the case on each matter. The starting point on matter 1, which are aims, objectives and need for the busway, is the need for the busway. It is that need which underpins the identified aims and objectives. The national need to unlock the growth of Greater Cambridge is expressed at local level in 2 clear imperatives. The first is to provide more houses and employment land in the right places. The second is to address the well-documented transport constraints in the region, in particular in gaining access to the city. So I turn to imperative 1, which is the need to unlock new housing and employment land. One of the identified drivers of the Cambridge phenomenon is the attractiveness of Greater Cambridge as a place to live, not just to do business. The consequences of insufficient housing are already starting to be felt. This is most obvious in terms of spiralling housing affordability, or lack of affordability. This adversely affects local residents and creates a supply issue for local businesses who want to grow their workforce. There are also other indicators in recent years of growing high-skilled job vacancies. Another of the identified drivers was the clustering of a world-class university with cutting-edge businesses. This facilitated cooperation and cross-fertilisation between entrepreneurs and academics. However, as is obvious, there must be space for these clusters to form and grow. And today, that space is not available in the quantities required. Cambridge is experiencing an acute and significant shortage of laboratory space. Since 2020, 5 years ago, the volume of laboratory floor space sought by companies in the city has exceeded the level of office space available. The City Council and District Council are facing this challenge head-on. The adopted development plan, principally composed of the South Cambridgeshire Local Plan and the Cambridge Local Plan, plans for 33,500 new homes and 44,000 jobs across Greater Cambridge by 2031. The planned growth includes significant housing growth on major allocations at both Bourne Airfield, that's 3,500 dwellings, and Cambourne West, allocated for 1,200 dwellings, but with planning permission granted for up to 2,350 dwellings and other uses, that is, commercial and community uses, as well as significant employment growth at West Cambridge, 383,000 square metres. The growth at Bourne Airfield is particularly dependent on the delivery of the busway. Delivery beyond 500 dwellings is prohibited by a planning condition in advance of the busway's delivery or equivalent provision. The City Council and the District Council are now promoting a new joint local plan. Although the plan-making process is ongoing, the direction of travel is clear, as are the principal components of the joint local plan. In particular, the joint local plan continues the central tenets of the established spatial strategy. Cambourne will remain a focus for growth. The allocations at Bourne Airfield and Cambourne West are maintained, and there are proposed new housing allocations in Cambourne to deliver 1,950 homes. The joint local plan continues to support the University Innovation District on the west of Cambridge. The objectively assessed housing and employment land needs are now higher still, and you'll recall the figures that I've read out before. 58,500 jobs are required by 2041, and 44,400 homes are required by the same date. In identifying these needs, the City Council and District Council have rightly gone beyond the standard method on the basis that housing must keep up with job growth. Overall, it's clear that development in Cambourne and to the west of Cambridge will be required to meet identified need. In this respect, the joint local plan has a clear vision to create vibrant and highly sustainable places in Cambourne, Bourne Airfield, and on the western edge of Cambridge. The growth proposals are premised on the assumption that the busway will be provided. The joint local plan expressly recognises that the busway will be, and I quote, significant improvement in public transport, which provides an opportunity to grow Cambourne as an existing new town, enhancing the critical mass of population, employment and services available locally to those communities. So that's housing and employment. Now transport. The transport constraints in Greater Cambridge are well documented, and on this issue above all others, there does not appear to be disagreement by the busway's objectors. In any event, the transport constraints are evidenced in the application. The transport assessment assesses future transport conditions without the busway, concluding that within the study area, especially the western Cambourne to Cambridge corridor, multiple junctions in both the AM peak and the PM peak, as well as in the interpeak, will experience high levels of queuing, traffic and delay, significantly in excess of acceptable levels. This is reiterated in the outline business case, which identifies that without intervention, that vehicle trips, in particular commuting by car, are forecast to grow and exacerbate existing congestion. The need for intervention is also well established and clearly evidenced. We have to go back some way in time. As early as 2014, the transport strategy for Cambridge and South Cambridgeshire identified a need for intervention on the Cambourne to Cambridge corridor, including segregated bus links on the A1303 or an offline alignment between the A428 and the M11, provision of an outer park and ride on the A428 between Cambourne and the A3103, and a busway on the A1303, or high-quality public transport infrastructure to serve Bourne Airfield and Cambourne. Subsequent transport plans have reiterated the need for intervention, and this includes the evidence base to the joint local plan, which takes into account the busway as part of its baseline mitigation and forecasts it taking a significant increase in public transport trips in the Cambourne to Cambridge corridor. So overall, the transport constraints are well documented, and they are a key driver of the need for the busway. Turning to aims and objectives, The busway's aims and objectives have been formulated in response to these identified needs. The overall objectives of the busway are to achieve improved accessibility to support the economic growth of the Greater Cambridge region, deliver a sustainable transport network or system that connects areas between Cambourne and Cambridge along the A428, A1303 transport corridor, and contribute to enhanced quality of life by relieving congestion and improving air quality within the surrounding areas along that corridor and within the city. The aims of the busway are formulated to meet these objectives. In summary, the busway aims to relieve congestion, support economic growth, in particular at Bourne Airfield and Cambourne, deliver sustainable transport routes for walkers, riders and horse riders, deliver a travel hub at Scotland Farm, providing park and ride, and enhancing quality of life, including through air quality and environmental improvements. And the busway delivers on these aims and objectives. So we turn to benefits. First of all, transport benefits. The busway will reduce bus journey times by 50% at the AM peak and increase bus patronage, 9,000 new trips a day out of a total of 10,000 trips, increase bus mode share and reliability. And those benefits have an estimated value of £49 million under the economic assessment. As far as economic benefits are concerned, the new homes that are unlocked will have both a social and economic benefit. The land value uplift is worth over £222 million. That's a present value, potentially 338 million. That depends on how many homes are unlocked. There will be additional benefits to the regional and national economy, a £100 million gross value added per annum uplift in Greater Cambridge, and nearly 3 million present value of benefits for the national economy. And I just ask you to note, sirs, that the economic benefits of the scheme, expressed in numbers, are significant and are based in large part in releasing and allowing the development of the housing and economic development at Cambourne and Bourne in particular. Social benefits, as already explained, the busway will unlock significant new housing growth, including Bourne Airfield with 30% affordable and Cambourne West with 40% affordable. These new homes will be coupled with improved and increased opportunities to use public and active travel, including notable benefits for those who are young, or, statement of the obvious, those who do not have access to a car. Environmental benefits, there will be a range of environmental benefits, including a net reduction in carbon emissions, improved open space, and significant biodiversity net gain. Taken together, this is a significant package of benefits which directly meet the identified need and satisfy the busway's aims and objectives. And we then deal with procedural requirements. We refer to the note of the 19th of June 2025, and you've heard the update on Rule 13. On alternatives, this is whether there's a realistic alternative or an equivalent or better alternative is a matter keenly contested by objectors. In particular, CPPF and on a different part of the route, Clare Hall, and all those who support the CPPF scheme. So we're just going to set out the applicant's position on the approach to be taken. In this case, the assessment of alternatives has been adequate, the required information has been provided, and the best option has been chosen. That's our case. In terms of the legal framework, we have the 2006 applications and objection procedure rules, which require, under Rule 11.1d, a description of the reasonable alternatives studied and the main reason for the options chosen. Two matters must be noted. The obligation is to study and provide information about alternatives for the purposes of informing the Secretary of State's reasoned conclusion pursuant to the 1992 Act. Thus, this obligation is about the provision of information, not about the attainment of a particular outcome. Environmental impact assessment is a tool, but it does not dictate an outcome. The least environmentally harmful option need not be the chosen option or the consented option. And at the EIA stage, in comparison to earlier stages of strategic environmental assessment, this does not require alternatives to be worked up in the same level of detail as the preferred option. And we cite the judgment of, passage from the judgment of Lord Carnworth in Buckinghamshire County Council and the Secretary of State in support of that proposition. And we also, in the footnote, refer to the Holohan case, in a European case. Equally, the reasons for choosing the preferred option over those alternatives need only be the main reasons. Thus, the statutory requirement does not require the detailed working up of alternatives or the provision of a detailed side-by-side comparison. I just say as an aside, and no doubt we'll come on to it this afternoon, in fact, in the OAR, the option appraisal reports, there is a detailed side-by-side comparison, but we're setting out the legal position. Outside this statutory framework of the Act and the rules, the principles in relation to alternatives set out in Mount Cook apply in relation to planning applications. And they are, whether any proposed use is acceptable in planning terms depends on whether it would cause planning harm judged according to relevant planning policies, where there are any. In the absence of conflict with planning policy and or other planning harm, the relative advantage of alternative uses on the application site or of the same use on alternative sites are normally irrelevant in planning terms. Where an application proposal does not conflict with policy, otherwise involves no planning harm, any alternative proposals would normally be irrelevant. Even in exceptional circumstances where alternative proposals might be relevant, inchoate or vague schemes and or those that are unlikely or have no real possibility of coming about would not be relevant, or if they were, would be given little or no weight. And when consider the planning position, you'll have to consider whether alternatives are deliverable, because if they're not, they can't be given much weight. When considering compulsory purchase of land, the principle of providing a reliable public transport service between Cambourne and Cambridge is generally accepted, as we've said. Once the principle is accepted, the question becomes, how will the objective be achieved? If alternative means of achieving that objective are put forward, they are to be considered when determining, as a matter of judgment, whether there is a compelling case in the public interest to justify the compulsory acquisition of land. If an alternative scheme is not deliverable, viable, or feasible, it can, as a matter of judgment, be rejected as not providing an alternative means of achieving the objective. And if an alternative scheme is considered to be deliverable, its advantages and disadvantages can be compared to the proposed scheme. A judgment must then be made on whether the alternative would serve equally well to achieve the desired purpose after all relevant considerations, including cost and, importantly, delay, have been taken into account. So even if an alternative was considered to be deliverable and equally advantageous, in deciding whether that would be a reason for rejecting the scheme, you would have to consider, amongst other things, delay. And that's a particularly important point given the imperative for this scheme in the wider Cambridge context. I turn to the assessment of alternatives in this case. The County Council has documented the assessment of alternatives in the environmental statement, including the addenda, and in its evidence. This assessment was detailed and extensive, including multiple rounds of consultation. The output of that assessment was the busway as it is presented at the inquiry. We do not rehearse the detail of this assessment process in opening, not least as the vast majority of the process is not in dispute and is not the subject of challenge by objectors, and also make the opening even longer than it already is. Instead, we focus on the three principal issues in dispute under this matter. Issue 1 is CPPF's alternative on-road option. As to this, on-road options were extensively assessed by the County Council, both before and after the preparation of the ES. This included the assessment of online options in its initial long list of 34 options between 2014 and 2017, as well as subsequent assessment of online options, including those promoted by CPPF at that time, during the preparation of the outline business case. Throughout those assessments, the offline option performed consistently better. The CPPF alternative has evolved over time, with a number of material changes being made in various different consultation responses, both formal and informal. It has never been possible for CPPF to fix its proposal for the simple reason that it has never been workable. The approach has persisted even in the preparation of its evidence for this inquiry. The County Council has produced two engineering assessments of the CPPF alternative. The conclusion of both these assessments is that the CPPF alternative is unsafe and based on a plethora of unacceptable departures from the relevant design standards. Put simply, the CPPF alternative is not viable. It does not provide a realistic means of delivering the scheme objectives. In these circumstances, it has no real prospect of coming about, and thus applying the established principles, at best, it is a consideration to which no weight can be afforded. The second issue is the alignment of the busway at Coton Orchard. Some objectors have suggested that the busway should have been realigned to avoid the original Bramley apple trees. This suggestion is made, and in using these words, they're not pejorative, they're just taken from the cases, is made vaguely and is inchoate. No objector has proposed a viable alternative. In any event, such an option was assessed in the preparation of the environmental statement, including specific consultation with the relevant landowners. That assessment and consultation demonstrated that the alternative was much less preferable. CPPF, as one of the landowners, considered the alternative to be inferior, and the assessment demonstrated that this alternative would have resulted in wider environmental impacts, as well as being inferior on operational and safety grounds. It follows that this alternative cannot be given any weight, even if it is a relevant consideration. The third issue is the selection of rifle range track instead of Adams Road. The point taken on behalf of Clare Hall. Both options were fully appraised through the preparation of the option appraisal reports between 2018 and 2019, with further consideration before the outline business case was reported to the GCP's Executive Board in 2021. As the second ES addendum demonstrates, the output of the appraisals is that the option appraisal reports is that the rifle range track is the better option once the now abandoned Cambridge Autonomous Metro is discounted. It follows that the Adams Road option does not provide a proper basis for objecting to the busway as now proposed. Further, even if contrary to the applicant's case, Adams Road were considered to be a potentially preferable option. When making a judgment, account would have to be taken of all relevant factors, including delay. Once those factors are taken into account, it's clear that Adams Road cannot properly be considered to be a preferable or equally advantageous means of securing the scheme objectives. Overall, there's been adequate assessment of alternatives, and following that assessment, the busway as now proposed is the best performing option. Turn to matter 4, effect of the implementation, operation and maintenance of the busway. This matter is wide-ranging. All of the relevant matters are assessed in the environmental statement together with the addenda and the other application documents. We focus here on the principal matters in dispute, namely impacts relating to Coton Orchard and separately, different part of the route, Clare Hall. Coton Orchard is a recently designated county wildlife site. It does not benefit from any national designations, and although the orchard was planted in 1922, most of its apple trees are of more recent origin. The orchard has been assessed in detail. The ES reports a significant effect, given the loss of about half a hectare of habitat. However, off-site compensation has been secured, and there does not appear to be any real dispute over the assessment of these effects. Turning to the older trees within the orchard, there are 6 veteran trees within the order limits with which the busway may interface. Retention of 3 of these trees, T5, T9 and T10, can be secured without their loss or deterioration. As to the other 3 trees, T6, T7 and T8, they cannot be retained in their present location, but they can be relocated without their loss or deterioration. In this regard, an acceptable location within the order limits has been identified at Rectory Farm, although there are other possibilities within the orchard which GCP is willing to explore with the landowner if she wishes to do so. It has been noted that despite earlier representations, no other party is now calling specialist arboricultural evidence, and in the evidence that is being called, there is very little disagreement on this issue. It follows that there will be no loss of irreplaceable habitats for the purposes of paragraph 193C of the National Planning Policy Framework. However, even if such loss did occur, it's the applicant's case that the busway remains in accordance with that paragraph. There are wholly exceptional reasons for their loss, and in this regard, footnote 70 of the MPPF specifically lists infrastructure projects under the Transport and Works Act 1992, where the public benefit clearly outweighs the loss or destruction of the trees. And the busway is such a case. It is essential infrastructure, where the identified public benefits clearly outweighs the potential loss or deterioration of 3 veteran trees. Further, a suitable compensation strategy exists and has been secured. I turn to Clare Hall. There are 3 principal issues. Heritage. The first issue is the impact of the busway on Clare Hall as a listed building. The busway will cause some harm to the listed building, but only by way of change in the building's setting. No physical harm is caused. In policy terms, the harm will be less than substantial at the low end of the spectrum. Clare Hall, in the applicant's submission, erroneously and inconsistently asserts a higher degree of harm, even though still less than substantial. Applying paragraph 215 of the MPPF, giving considerable importance and weight to the desirability of preserving the setting of the listed buildings, it's the applicant's case that this harm is outweighed by the public benefits of the busway. Flooding. The second issue is the impact of the busway on flooding from Bin Brook. The County Council is engaged in lengthy and detailed discussions with the Environment Agency, and the Environment Agency has removed its objection. The County Council's flood model is agreed to be fit for purpose. It is agreed that the busway will not increase flood risk elsewhere. On this basis, the EA concludes that the flood risk assessment meets the MPPF's requirements on flood risks. The sequential and exception tests are also met on this basis. And obviously in the evidence we would go into more detail on that. Significant weight should be given to the views of the EA, both as a matter of principle and particularly in this case, given the extensive and detailed discussions. Accordingly, a good reason is required to depart from the views of the Environment Agency, and it's the applicant's case there is no such reason. In particular, Clare Hall's case on this issue is premised on there being disagreement with the Environment Agency, which is no longer the case. Clare Hall seeks to repeat objections made by the Environment Agency at an earlier stage, which have now been overcome, and those objections cannot be sustained now. As far as noise is concerned, these impacts have been assessed on a conservative worst-case basis. It's likely that the impacts have been overestimated. In any event, significant effects were only identified in the ES during construction in 3 limited areas. One of those areas was adjacent to Binbrook Bridge. Operational noise levels will remain by below significant observed adverse effect levels at all times and will be below lowest observed adverse effect levels during the daytime, and adopting restrictions on use proposed by the County Council will also be below the lowest observed adverse effect levels during the night time. Understood in its proper context, the noise impacts are acceptable. Turning to other identified items, finally, in respect to the items identified under this matter, which are not principal matters in dispute, the Council's headline position is as follows. The busway will not have an adverse impact on East West Rail and vice versa. In their representation letter, East West Rail Company state that they strongly support the principle of the Cambourne to Cambridge project, and in their written submissions they recognise that their concerns can be overcome by imposition of a suitable condition. Principles for a collaboration agreement have been agreed, and it's anticipated that the concerns raised can be resolved by entering into that agreement or by condition. The busway will not have any adverse impact on the significance of the Grade 1 registered park and garden of the American Military Cemetery at Madingley. Indeed, the American Battle Monuments Commission has written in support of the busway, stating that it favours development options which avoid expansion of the A1303. Although impacts on some other heritage assets has been identified, all those impacts are all individually and cumulatively at a low level. In national policy terms, these impacts amount to less than substantial harm, and applying the paragraph 215 MPPF approach, that less than substantial harm is outweighed by public benefits of the busway, which have already been summarised. The busway does lie in part, and by no means entirely, within the Greenbelt. This is inevitable with any project in the Cambourne to Cambridge corridor. A detailed Greenbelt assessment has been undertaken. Having regard to that assessment, although the impact on the openness of the Greenbelt and the purposes of including land within the Greenbelt is generally low, and in some places openness is in fact preserved, nevertheless, overall, the busway falls into the category of inappropriate development in the Greenbelt. However, the harm by reason of inappropriateness and other identified harms is clearly outweighed by a package of very substantial benefits, the demonstrable need for the busway in the absence of viable or preferable alternatives such that very special circumstances exist. we turn to matter 5, effect on statutory undertakers, statutory utilities and other utility providers. The busway will not have an adverse effect on those categories of person or their ability to carry out their undertakings effectively, safely and in compliance with any statutory or contractual obligations. Protective provisions have been incorporated in the draft order where necessary, and no doubt we'll turn to those this afternoon. There is no objection from such undertakers, and there's no substantive dispute under this matter. Turning to matter 6, compulsory purchase. The proposed order contains powers of compulsory purchase to ensure that the busway can be delivered and operated. These powers relate to both the temporary and permanent acquisition of land and rights over land along a corridor within defined limits. The corridor allows sufficient space to construct the busway itself, together with other essential components, such as the travel hub, maintenance track, public transport stops, bridges and ancillary works necessary for mitigation. The applicant has actively engaged with affected landowners and occupiers over a number of years, resulting in agreements, either executed or agreed heads of terms, with nearly half of the affected landowners and occupiers. As to those with whom agreements have not yet been reached, the applicant continues to engage where possible. The applicant has made offers to 7 of those parties, and negotiations on those offers continue. GCP has also made offers to 3 further parties, and that is CPPF, Houston Crest, and associated company, and Anna Gaisley, and the Spearing family. But unfortunately, these parties have not materially engaged. The 2 remaining parties relate to statutory undertakers, in respect to which negotiations continue, with progress being made. It follows that there is a realistic prospect of further progress and agreement, such as to avoid the need for compulsory purchase in the vast majority of these outstanding cases, but not all. In respect to those cases where agreement cannot be reached, the County Council submits that compulsory purchase is justified. In particular, there is a compelling case in the public interest having regard to the identified need for the busway, the benefits of delivering the busway, and the absence of a viable or preferable alternative route. Although there may be an interference with some landowner or occupier human rights, given the nature of the land being acquired, principally farmland, this interference is with rights under Article 1, Protocol 1, that's the right to property. Further, and in any event, that interference is lawful and proportionate, having regard to the relatively small amount of land taken. The steps taken by GCP to mitigate that land take and the countervailing need and benefits of the busway. There are no impediments to the delivery of the busway once compulsory acquisition has occurred, and GCP are demonstrably committed to the busway and the required funding has been secured. In all the circumstances, the compulsory acquisition is necessary to deliver the busway. We turn briefly to the Section 19 certificate application. The replacement open space is assessed in the open space assessment. There can be no doubt that the proposed area of open space meets the quantitative criteria, and as far as quality is concerned, the replacement open space will form part of a wider area which will be the subject of enhancement and improvement. Access to that area can be obtained from both sides of the M11 via the bridleway. It is the applicant's case that the area to be provided as open space will be equally advantageous to the public. So in conclusion, drawing these threads together, there is very strong national and local support for the delivery of the busway. This reflects the demonstrable need for improved infrastructure to help unleash Cambridge's economic potential. The busway meets that need and delivers a package of very substantial benefits. There are no viable or preferable alternatives. Whilst there are, inevitably, some adverse impacts, principally from the construction of the busway, those adverse impacts are clearly outweighed by the benefits secured. And for these reasons, as the County Council will expand in its evidence and submissions, the County Council submits that in due course, the draft order should be made, a direction should be made that planning permission be deemed to be granted, and a Section 19 open space certificate should be issued. And those are our opening submissions. And of course, if anything's unclear, we'll try and clarify it.
Thank you, Mr. Cameron. Mr. Applicant Writer, please. Thanks, Mr. Cameron.
This is the opening statement on behalf of Cambridge City Council and South Cambridgeshire District Council in this inquiry into the applications for the Cambourne to Cambridge order. I won't repeat those applications as the applicant has already set them out in its opening. Together, the applications seek permission for the development of a new segregated guided busway from Cambourne to Cambridge, a park and ride facility at Scotland Farm, and an emergency and maintenance access track running along the length of the busway for pedestrians, cyclists, and for most of the length of the track, equestrians. The councils are the local planning authorities for the administrative areas in which the scheme will be implemented, and as such are statutory consultees for the proposed order, pursuant to sections 10 and 11 of the 1992 Act and rules 21 and 23 of the 2006 rules. The councils have a separate role in relation to the scheme as members of the Greater Cambridge Partnership Executive Board, on which they have voting rights on decisions relating to the commissioning of projects funded by money provided through the City Deal. The scheme is one such project. Following the decision of the GCP Executive Board to approve the making of a formal request to the County Council to approve the submission of a Transport and Works order, and the submission of the applications for approval of the scheme by the applicant on behalf of the GCP, the councils appear at this inquiry solely in their role as local planning authorities for the areas affected by the scheme. The provision of a high-quality public transport access corridor between Cambridge and Cambourne is a central plank of the council's adopted development plans. It is necessary to achieve the spatial development strategy and the sustainable development objectives set out therein, as well as enabling anticipated further growth beyond the planned period. It is essential for a number of reasons, which include to support housing delivery, economic integration and expansion, research and education, sustainable transport goals, equitable access to opportunities for all, and to underpin the national and international importance of Cambridge as a science hub. The councils have therefore supported the need for and principle of the scheme throughout. Following extensive constructive dialogue with the applicant, the councils consider that the matters raised in their statements of case can be resolved through the imposition of conditions which have been agreed with the applicant. A statement of common ground between the councils and the applicant is well progressed. It is anticipated that it will be agreed shortly and will confirm alignment of the parties on all material matters, subject to any refinement of wording of proposed planning conditions during the course of the inquiry. While the scheme results in some unavoidable impacts, these are capable of mitigation to an acceptable degree. Harm to the Greenbelt and to heritage assets is outweighed by the significant public benefits of the scheme, which amount to very special circumstances. The Council's position at this inquiry is therefore one of supporting the scheme. Bearing in mind the critical role that the scheme plays in delivering the Council's spatial development strategy and identified housing and employment needs, both now and into the future, the Council's primarily appear at this inquiry to support the applicant's case on matter 1, the aims and objectives of and the need for the proposed Cambourne to Cambridge guided busway. The evidence provided on behalf of the Council will also confirm their view that the scheme is acceptable in planning terms. Turning first to the spatial strategy. The spatial strategy for Greater Cambridge essentially seeks to balance the need to safeguard the qualities that make Cambridge and its environs special and contribute to their desirability as places to live, study, work and visit. And those qualities are the historic character of the city, its compact urban form, and the setting provided by the tightly drawn Cambridge Greenbelt. With the growth needs of Greater Cambridge in supporting a centre of international economic significance and a highly developed knowledge-based economy. The strategy, which has evolved through successive development plans since the late 1990s and close working between the two councils, is well developed. It has been promoted, tested, and consistently endorsed by the councils and by inspectors examining development plans. Central government has provided financial and policy support for the strategy via the City Deal in 2014 and the Case for Cambridge in 2024. Essentially, the strategy seeks to focus growth in accessible locations in and around Cambridge, while supporting the delivery of new communities at a sustainable scale in locations beyond the Greenbelt, where existing or planned public transport can support such development while reducing car dependence. The strategy is taken forward in the developing proposals for a joint local plan for the Greater Cambridge area. This emerging plan maintains and builds upon earlier commitments to introduce or expand settlements beyond the Greenbelt, where comprehensive infrastructure can be planned from the outset, and it seeks to concentrate growth along corridors where high-quality public transport, cycling and walking infrastructure is or will be in place. The scheme is aligned with and crucial to the delivery of this latter aspect of the spatial strategy. That is particularly evident in policies SS7 and SS8 of the South Cambridgeshire District Council Local Plan 2018, which both rely on improved public transport to support the scale and accessibility of the housing allocations at Bourne Airfield and Cambourne West, respectively. Without radial public transport links such as the scheme, described in the City Deal as the backbone of the strategy for growth, Cambridge will be unable to grow sustainably and equitably in line with its spatial strategy. The need for the scheme. The scheme is not only a key measure for the delivery of the spatial strategy set out in the adopted plan, but it is also an enabler of infrastructure-led wider growth to support the Cambridge economy and its residents into the future. In addition, it offers a near-term and rapid measure to ease the impacts of existing traffic congestion and high house prices on those living and working in Cambridge and its western environs, in advance of and complementary with larger-scale transport interventions such as East-West Rail. Realising the economic potential of Cambridge is likely to require a growth strategy that goes further than the local plans in terms of scale, ambition and timescale. It would therefore be wrong, as some objectors to the scheme have done, to focus simply on the identified need and allocations identified in the adopted local plans when assessing the need for and principle of the scheme, albeit the scheme is necessary in any event to deliver the planned development in those local plans. The scheme aligns with and supports a number of critical growth drivers and strategic objectives for Cambridge identified in adopted and emerging policy at local and national level. Unlocking housing growth. The scheme will enable significant housing growth at Cambourne West and Bourne Airfield to proceed in a timely, sustainable and viable way, which respects the local and national priority to respond to climate change. In advance of a high-quality transport link such as the scheme coming forward, development at Bourne Airfield is limited to 500 dwellings. The scheme would also support the further growth at Cambourne envisaged in the emerging joint local plan, which, following the recent changes to the standard methodology for calculating housing needs, is required to provide for a materially higher number of new home completions than that planned for in the adopted local plans. Supporting economic growth, labour mobility and innovation clusters. The scheme supports the globally significant employment hubs in life sciences, AI, clean technology, and advanced manufacturing based in Cambridge by improving access to Cambridge from the west, and specifically the West Cambridge campus of the University of Cambridge. It widens the labour pool for these employment and research hubs, enabling public sector staff, support services, and early career researchers who may not own cars and might otherwise be priced out of the Cambridge housing market to commute reliably and affordably into Cambridge. In doing so, it facilitates the success of these hubs and widens participation in Cambridge's economic growth, as well as supporting cross-pollination between academia, business, and the wider regional labour market. Without initiatives such as the scheme, the lack of sufficient, accessible and affordable housing for its workforce is a potential constraint on the ability of Cambridge to maintain and improve its world-leading position in science. Aligning with sustainable and transport and climate goals, the A428, A1303 has long been identified as a corridor of significant congestion where transformational modal shift is required. The scheme facilitates such a shift by, among other things, providing a reliable, low or zero emission alternative to car use between Cambourne and Cambridge, intercepting future private car trips towards the city as a result of anticipated growth within the Oxcam growth corridor, increasing the capacity of park and ride travel hubs serving the city, and by promoting walking and cycling via the parallel active travel route. It aligns with local net zero ambitions and national climate change goals, as well as contributing to improved air quality through the reduction in private car use. Meeting the needs of communities and social inclusion. The scheme aligns with and supports the Council's commitments in adopted and emerging policy to sustainable and inclusive growth. It enables those without access to or use of a car, or who cannot afford to live in the city, to reliably reach employment, education, healthcare and cultural opportunities in Cambridge. It will enable emerging businesses to take advantage of more affordable employment locations beyond the city and along the scheme corridor, without further burdening congested road infrastructure or losing employees due to poorer accessibility. Compliance of the scheme with planning policy. While the councils acknowledge that Section 38(6) of the Planning and Compulsory Purchase Act 2004 is not directly applicable to the present application for deemed planning permission, the adopted development plan is an important material consideration in determining that application, along with the MPPF and the emerging joint local plan. The councils also have a responsibility to ensure that development in their administrative areas is undertaken in a sustainable manner. As such, the councils have reviewed the scheme, including its supporting documents and environmental statement, against adopted and emerging policy and guidance. They have identified a strong measure of compliance and alignment with important strategic policies for infrastructure-led development. The loss of open space would be mitigated by the re-provision of an area of equivalent size in close proximity to the affected locations and incorporating qualitative enhancements. A planning condition would ensure that the replacement open space would be fully available to the public on the opening of the scheme. The councils recognise that the scheme would result in a number of localised harms. These include less than substantial harm to the significance of designated heritage assets, including listed buildings and conservation areas, engaging legal duties in the Planning, Listed Buildings and Conservation Areas Act, harm to the green belt by reason of inappropriateness, impact on openness and conflict with purposes, and minor residual harm to trees, landscape character, and best and most versatile agricultural land. However, these harms are outweighed by the substantial public benefits of the scheme. Those include the creation of a fast, reliable, congestion-free public transport spine connecting strategic housing allocations to the west of Cambridge with major employment and education hubs in the city, critical support to the adopted spatial strategy by unlocking and sustaining the delivery of at least 6,000 new homes in the Western Corridor, associated carbon reduction, air quality improvement and modal shift outcomes, enhanced network resilience and capacity through the provision of high-quality active travel links, open space and green infrastructure improvements, integration with future infrastructure, and improving equality of opportunity for non-car users. even giving the harm identified to heritage assets considerable importance and weight, as required by statute and the NPPF, those public benefits are sufficient to justify the grant of deemed planning permission. They are also of sufficient weight, considered together, to amount to very special circumstances which justify the grant of permission for inappropriate development in the Greenbelt. So in conclusion, the scheme is critically important to enable the delivery of adopted development plan policy and the future expansion of Greater Cambridge in a sustainable and equitable way. The identified planning harms resulting from a scheme of this nature can be minimised appropriately through mitigation schemes and planning conditions, such that the resulting level of residual harm is low and is outweighed by the significant public benefits that the scheme will bring. You are therefore respectfully asked to recommend to the Secretary of State that the order be made, a direction be granted pursuant to Section 92A, and a certificate be issued pursuant to Section 19.
Thank you, Mr. Applicant Writer. Can I just take you to your paragraph 6?
Yes.
Where you mentioned statement of common ground. You'll have heard what we said earlier. So could I say the same thing to you, that if you can conclude that and get something to us by the end of this week, that would be very helpful.
I believe it is with the applicant at the moment.
Yes, that's what I've heard from other parties.
Yes.
Yeah,
thank you.
But if you could encourage the production of that, and I think you alluded to conditions around that time. If there could be part of that, that would be helpful as well.
Yes, I understand that. That's the position.
Good. Thank you very much. And I think it's Mr. Parker now. Sorry, Mr. Cameron, did you want to? No.
I'm afraid we've only managed to print out 2 copies, but I've circulated by email the opening to my colleagues. I'm hopeful that they should have reached their inbox.
We could share for now. I'll get one later.
I'm grateful. I'm hoping that you should have it for them. Hopefully it should be any.
Just got it.
You circulate. Yeah. It should. I understand it should be with you in a moment or two. Good. Okay, Mr. Parker.
Thank you, sirs. CPPF and CPC acknowledges and agrees that there is a need to meet the objectives set for the scheme to improve accessibility in the Greater Cambridge region, to support economic growth, to deliver a sustainable public transport service between Cambourne and Cambridge, and to improve the quality of life within surrounding areas. The question for this inquiry is, however, whether the scheme that has been put forward to meet those objectives is justified. CPPF and CPC is firmly of the view that it is not, and will seek to demonstrate why in detail through the evidence presented to the inspectors. CPPF, CPC's concerns about the scheme are rooted in the applicant's proposal to construct an offline busway between the Madingley Mulch roundabout and Grange Road on the western side of Cambridge. That proposal is of considerable concern because A, it will involve the compulsory purchase of land, including land owned by CPPF as part of its charitable purposes and held for the specific purpose of protecting the setting of the historic village of Coton and the countryside setting of Cambridge. And secondly, it will cause significant harm to the Greenbelt, as well as landscape harm, ecological harm, and other environmental harms. Given that the scheme involves the need for compulsory purchase, there must be a compelling case in the public interest. Given that the scheme will cause obvious harm to the openness of the Greenbelt, there must be very special circumstances to justify it. CPPF and CPC are firmly of the view that such justification is lacking. While the scheme would involve a number of disparate elements, including the busway, a maintenance track, and a park and ride facility, the central transport benefit claimed for the scheme is that the busway infrastructure will enable a faster and more reliable bus service to take more passengers from Cambourne to Cambridge than the due minimum would permit, the due minimum being a term of art to describe the existing infrastructure plus other committed schemes. Pausing there, it is important to note that the evidence put forward by the applicant is only claimed to demonstrate that the scheme would make a material improvement to inbound journeys, that's to say Cambourne to Cambridge. All that the applicant has said in relation to the benefit of the provision for outbound bus journeys is that congestion is likely to worsen so as to justify its provision in future. There is no actual evidence that outbound congestion will worsen significantly, nor that provision of an outbound bus lane will be required. There is therefore no justification for the outbound busway lane provided by the scheme. Given that inbound bus journey time savings and increased bus patronage by comparison with the due minimum are fundamental to the justification for the scheme, it is obvious that the evidence in support of the forecasted journey time savings and patronage is of fundamental importance to an understanding of the merits of the scheme, and in particular, whether the compulsory purchase of land is justified. CPPF and CPC will demonstrate that the evidence relied on by the applicant to demonstrate that the scheme will deliver the transport benefits which are said to justify it, that's to say inbound bus journey time savings and increased patronage, is wholly inadequate. In particular, the transport modelling underpinning the claimed inbound bus journey time savings and patronage is the Cambridge sub-regional model, referred to as a CSRM, the most recent iteration of which, the F-Series, is based to 2019, prior to the COVID-19 pandemic. The government has made clear that, and I quote, "The COVID-19 pandemic has had a significant impact on the pattern and volume of traffic, with overall volumes for most modes still below pre-pandemic levels, as can be seen in DFT official statistics, and importantly, below pre-pandemic projected demand levels. There are a multitude of drivers of behaviour and demand. It is difficult to isolate the individual impact of COVID-19, and the extent to which impacts will be sustained long-term is unclear. However, it is the Department's view and recommendation that this evident suppression of travel demand relative to a pre-pandemic projection of demand at this time should be appropriately represented in transport analysis. This is important particularly in appraisal and analysis supporting transport investment decisions. There can be no question, having regard to this guidance, that, as at today's date and when the application was made, the transport modelling supporting the outline business case, the addendum business case and the transport assessment, all of which is based on the pre-COVID CSRM, is, at least in isolation, an inadequate basis to justify the scheme. The most obvious way that the applicant could have remedied this deficiency would have been to produce a new transport model or to have rebased the CSRM using a post-COVID base year to forecast bus journey time savings and patronage. Such an approach is identified to be the ideal method identified in the DFT transport appraisal guidance. Given the fundamental importance of the journey time forecasts to the justification for the scheme, it is CPPF and CPC's position that it is the only way that the use of CPO powers could sensibly be justified. While TAG does envisage scenarios in which rebasing of a model may not be feasible or proportionate, that cannot sensibly be claimed to be the case here. There was ample opportunity between the establishment of the post-COVID new normal and the submission of the application to rebase the existing model. The applicants only attempted any transport analysis representing the evident suppression of travel demand post-COVID is a sensitivity test reported over 6 paragraphs of a technical note whereby the CSRM model was run with a 10% reduction in car travel and 10% increase in LGV travel. CPPF and CPC will show that this sensitivity test fails in fundamental respects to accord with the government's own guidance, fails to account for one of the most obvious changes in post-COVID travel behaviour, that's to say the suppressed public transport demand for which there is ample evidence both nationally and locally, and is ultimately a wholly inadequate basis on which to make a decision as to whether the scheme is justified, let alone whether there is a compelling case to justify the compulsory purchase of land. The applicant, latterly, appears to accept that the transport-related benefits of the scheme are modest, and has pivoted to an argument that, irrespective of whether the scheme will in fact deliver any transport user benefits, that it will nonetheless deliver significant economic benefits by unlocking housing development to the west of Cambridge. In particular, the applicant claims that 3,850 homes at Cambourne Westbourne Airfield are dependent on the delivery of the scheme, and that the scheme will, independently of any modelled transport user benefits, deliver a large land value uplift in the region of £184 million through their delivery. Such claimed dependency derives from historic transport assessment, which suffers from the same flawed dependence on the CSRM, and CPPF and CPC will demonstrate that the LVU claimed for the scheme is exaggerated. Aside from this fundamental deficiency in the evidence base, CPPF and CPC will demonstrate that the applicant's analysis is flawed in other ways, by reference to the assessment of the effects of East-West Rail, biodiversity net gain and ecological harm generally, CO2 emission benefits, alternatives to the scheme, the extent of harm caused in landscape and visual terms, and the green belt, whether the maintenance and access track falls within the scope of the order, and any event, whether there is a need for or commensurate benefit from its delivery, whether the proposed replacement open space is acceptable, and whether there has been adequate engagement by the applicant in relation to the proposed route alignment and land required. CPPF and CPC contends that the deficiencies above are such that the order scheme, as presented, is not justified. However, as part of its case, CPPF and CPC will also demonstrate that there is a further reason why the order scheme is not justified, namely an alternative in-highway scheme, referred to as the CPPF alternative, which would, subject to refinement through detailed design, as would be expected for any scheme of this nature, A, be effective in meeting the objectives of the scheme, B, be feasible in engineering terms, C, be safe, D, cause less harm to ecological receptors in the scheme, E, preserve the significance of heritage assets, F, be in compliance in principle with relevant development plan policy, G, be less harmful in green belt and landscape and visual terms, H, deliver upon the objectives of the scheme, I think that's a repetition, I, be significantly less costly, and J, be deliverable far more quickly than the order scheme. It is notable that the applicant has emphasised the need for interventions to accelerate and unlock growth in the short term, as well as raising the possibility that the busway may be repurposed in the future once longer-term proposals for wider transport solutions have been delivered. Both of those factors provide further justification for the CPPF alternative. It could be delivered more quickly so as to unlock growth in the short term, and it would avoid the need for a significant, time-consuming and costly incursion into the green belt for a scheme which is likely to become obsolete, or at least its benefits significantly curtailed in the medium term if and when East-West Rail is constructed or some other mass transit scheme is advanced as part of the future plans for the area. Through its evidence, CPPF and CPC will demonstrate that the order scheme is not justified, and we will respectfully invite the inspectors so to recommend.
Thank you, Mr. Parker. Does any other party wish to make an opening statement? Right. Nobody's indicated, so at this point we've heard opening statements, and as I mentioned earlier, we'll take the lunch adjournment now and resume at 1:45 for the roundtable sessions. The inquiry is now adjourned. Thank you.